Hi everyone, Judicial Watch President Tom Fitton here with a Judicial Watch special report. Well, you remember the Hillary Clinton email scandal? It hasn't gone away. In fact, there was a major lawsuit development in the Judicial Watch case that broke open the Clinton email scandal. And here to discuss it with me, the lead attorney on our Hillary Clinton email scandal lawsuit, Senior Judicial Watch Attorney Ramona Kotka. Thank you, Ramona, for joining us.
Sure. Thanks, Tom.
Well, we had a big development recently with the Hillary Clinton email scandal. And I don't know, maybe do you want to start at the beginning or start at the end? Let's maybe start at the end so we can explain later. We had a Freedom of Information Act lawsuit that uncovered the email scandal. We'll talk about how that came about. But the lawsuit ended. And it ended in a way that's not unusual for Foya lawsuits, but it was unusual for the amount and to me, what the conclusions one could draw from what happened at the end. So tell us how the Foya lawsuit ended. Again, it was in federal court here in the District of Columbia.
Yes, and this was the case before Judge Lamberth, as you know. And the point is, with Foya, any Foya case, at some point it comes to an end.
So Foya is?
Freedom of Information Act, right? And we're asking for records from the government. And at some point, it's either we have them, we've given you everything we have, or we don't, and then we have this long drawn-out lawsuit like we did in this case. But at some point, they do come to a conclusion. We had, and we'll get into it in a little bit, but several rounds of discovery in this case. And most recently,
what is discovery?
Request and exchange of information. And since we are the requester in this case, the plaintiff asking for records from the government, all the discovery went from our side to the defendants, to the agency.
So we were getting evidence and taking testimony and such from witnesses.
Correct. And we did a couple rounds of that, and we got incredible information that hadn't been disclosed before. This is about the Benghazi talking points from, following the attack on the U.S. consulate back in 2012. But most recently, what happened? We did settle this case, and under Foya, was a requester.
So when we settle it, who are we settling it with?
With the agency, the federal agency.
And the agency in this case was?
The State Department.
And the State Department.
So we often refer to as DOJ as well because the Department of Justice is involved, and that's because the Department of Justice represents the underlying agency.
So who's really running the show in those cases? Is it, in your experience as an attorney litigating FOIAs, are you dealing with the agency counsel or you're just dealing with the DOJ more or less?
We're dealing with the DOJ. Yes. So
they have to come in and explain what their clients have done in terms of obstructing our FOIAs, right?
Well, and
or try to defend what they've done.
Correct.
And so you kind of talk about how all FOIA cases end. Kind of the funny way of thinking about it is we lose all of our FOIA cases, right?
At some point.
The court says the case is over. You've gotten all the documents you're going to get, and it's over. Of course, we win by educating people through the filing as to what we're looking for and what the issues are. But
and
secondly,
pressing the agency when it hasn't done enough.
Right, forcing them to comply with Foya under the law. So the process is a victory. In the end, it just ends, right?
Correct.
And the Justice Department doesn't get hauled up on the docks for obstructing Foya, however much we might like that. And so when we settle, what is there to settle? What did they give us? They give us money? How does it work?
Under the Freedom of Information Act, you are requested under certain circumstances for fees, for legal fees and costs. And in this case, the fees were pretty extraordinary. We sometimes in certain cases, there's certain limitations as to what you can ask for. In this case, we requested $97,000 to cover our costs. It was been a long, drawn-out case. And the Department of Justice and the State Department, I believe, realized that it was a very reasonable request from Judicial Watch because they came back and accepted our demand.
For?
$97,000.
$97,000. Well, that is unusual. I mean, we do settle a lot of FOIA cases, and usually the amounts are much less significant than that. Now, they don't admit that they did anything wrong with settling, do they?
No, I mean, and that's just typical in any settlement, that neither side is going to admit liability.
But everyone can draw their own conclusions, right, about why they settled and why they gave us all that money. So the State Department paid, and taxpayers paid Judicial Watch, and I know some of you may be frustrated with that, $97,000 because of what Hillary did.
Yeah, I mean, and whether there's frustration, I mean, it was 10 years of litigation.
Yeah.
There was a lot of time and a lot of resources that we used to litigate the case, to be able to obtain information. Initially, and about the talking points, right, because that's how this all started. But then, because of the way that Secretary Clinton used her email to conduct state government business, there was all of this other discovery and all this other work we had to do.
So there are like two or three, I would say 3 or 4, probably 3 key lawsuits that kind of created the issues for Hillary Clinton. And the first one was filed almost immediately after 9/11/2012, the Benghazi attack. We quickly saw that there was a cover-up. Hillary and Obama were lying about the nature of the attack. It was a terrorist attack. A video didn't make them do it. It was pretty clear.
It wasn't a protest.
Right. And so we did our FOIA request and then lawsuit.
Right.
And we did get some documents about the Benghazi attack, including, you referenced the talking points. Explain what that is, because the talking points document we obtained kind of broke open the whole scandal.
Well, so prior to this lawsuit, the one that you are speaking of, I believe, is the one where we did actually obtain the email, the Ben Rhodes email, if you recall. Which
Ben Rhodes was an Obama White House official.
Correct, because initially this was all a State Department. The response was that this was a State Department response with respect to how they characterized the attack. And then in that case, we obtained the Ben Rhodes email. And so that led us to file additional lawsuits. And in this case, what we requested was the talking points that were provided to Susan Rice and records about those talking points when she appeared on all the morning talk shows the following Sunday.
So we got the talking, so people can remember, it's 10 plus years now. They didn't want to do a select committee on Benghazi. They had 5 or 6 House committees, a Senate committee looking into it. And little old Judicial Watch, and Ramona, your case, uncovered kind of a smoking gun.
Right.
Which is the Obama people were saying, well, when we said it was a protest, we were just basing it on our intelligence. This was intelligence we were getting.
Right.
And these talking points showed it was actually Obama White House PR operation that said, let's blame it on a video and make lemon out of a lemonade.
Exactly.
And, or lemonade out of a lemon. Arguably they screwed it around either way. And so Congress was outraged. And even, I think it was Boehner at the time, said, enough with this, I'm done covering, and we're going to have a select committee.
Right.
And so as you highlight, we followed up with another lawsuit because we had these talking points, now we wanted more information about them.
Right.
Now, as I recall, and I think you and I think I'm not telling any secrets, we're talking around the office like, where are Hillary's emails?
That's right.
And then the second round came and we said, where still are Hillary emails? And then what did you do to follow up on the inquiry about where's Hillary?
Well, so they responded, well, by they, I mean the State Department and the Department of Justice responded in our case, and this current one that just settled. And their initial response to our request was, the only records we found are the same 4 documents that we gave you in this prior case where we obtained the Ben Rhodes emails and the smoking gun that you referred to.
So we already gave you the emails.
So
there
we
are no
already
Hillary
gave you,
emails.
and we didn't have any Hillary emails there. But this one was specific to the State Department and to the Secretary's office, this request. And there were absolutely no Hillary emails. And when they responded back in November of 2014, we went back and we said, okay, well, provide us an explanation for where you looked. And if you recall, in December is when Secretary Clinton delivered the boxes of emails. And The State Department.
They started giving you a little runaround then.
The State Department came back and said, we need a little bit more time because we have a couple more places to look at.
And then they filed something in February 2015. What did they say?
In the joint status report. That's when they said they have additional places they need to look at. But they didn't disclose.
So a joint status report is what?
It's basically both parties or all parties, if there are multiple parties, more than two. So it was Judicial Watch and the State Department in this case, providing a status, an update to the court of where the parties are in discussing what records we want or were requested and where the agency is with respect to responding to that request, where they looked or how many records they found.
And so the State Department said Judicial Watch is awful, and we gave them all the records, except some others we may have to look at. Am I correct in, maybe I'm slightly mischaracterizing how awful they said we were, but they basically took the attitude, Judicial Watch is crazy, they've gotten everything, there's some other things we need to look at, but this case needs to end soon.
Correct. And by the way, one thing I didn't mention, back in November, they provided us the records, and we asked, okay, we want also a search declaration, a draft search declaration, and that was all as part of the discussions of trying to settle the case.
Oh, so we wanted to know if we got all the documents. We got all the documents. Let's talk about ending the case, right?
Correct.
Fight about what records are being withheld. And a search declaration is the agency explaining to us in the court what?
Basically attesting and describing where they looked for the records to make sure under Foya, under the Freedom of Information Act, the agency has to show that it's conducted a reasonable search.
So in February of 2015, in response to a Judicial Watch Foya lawsuit, we had the first indirect but public disclosure of the Clinton email scandal.
Right.
And they didn't tell us it was the Clinton email.
What the source was of records, but yes.
And a few weeks later, it was leaked to the Associated Press that Hillary had an email server.
Yes.
And all you know what broke loose from there.
Correct.
And it turned out they had hidden all of these emails from the American people. Hillary stole the emails on her way out the door, deleted or attempted to delete 33,000, and that's all she wrote.
They did delete a bunch.
Right.
They did delete 33.
But some of them were recovered. Right.
Right.
So what did we do then? We had this case going on. We asked Judge Lambert, who was a federal district court judge here in the District of Columbia, to get some discovery to figure, because this was outrageous.
Absolutely.
And then there was the concurrent case that had ended. I say concurrent, but it was we were kind of sniffing around the same issues. Huma Abedin, right?
It was on its. We had done some discovery in that case, and that was with respect to Huma Abedin records.
So that case had already been closed, and the court it was Judge Sullivan, Emmett Sullivan,
right,
who's now a senior judge. I think he's still on the bench.
Yes.
He reopened that case because of the new Clinton emails.
Yes, that's right.
And so, and people think I'm leading Ramona. I'm actually trying to remind myself what happened as I'm talking to Ramona, since it was so long ago. So Judge Lambert said, Sullivan reopened the case and has granted Judicial Watch discovery. So I'm going to see what you all find there, right?
Correct.
And he didn't want discovery on the same issue.
Don't have it overlapping.
Right. So you questioned some folks in this other case, including Huma Abedin and Cheryl Mills. Abedin was a close aide to Hillary Clinton from going way back, but even more importantly, Cheryl Mills was her top lawyer in the State Department, was her top official in the White House when she was First Lady, and then I don't remember what she did for her in the Senate, but she was very close to Hillary. Right. And we deposed, Judicial Watch did a few other folks. Do you recall what interesting information we got from Miss Mills and Abedin? Miss Mills wasn't too forthcoming, as I recall, or I don't want to say that she was, quote, lying, but she was not in a sharing mood.
No, I believe her responses, and this takes me back to, back quite a number of years, but I believe,
Getting
not that
some
we're talking about
Are you
it,
getting some PTSD from the
I think her
testimony?
responses were, I don't have specific recollection of this. And I was trying, we were trying to say, well, how about a general recollection? But it was just a very, very slim or vague responses with respect to the details about Secretary Clinton's emails.
And Miss Abedin was I think she was still married to Anthony Weiner at the time, but she gave us some very interesting information about who was responsible for this email scheme. Didn't she say Hillary did it? It was Hillary's idea that we should ask Hillary about the email issues.
That's right, because following those depositions, if my memory's correct, I believe Judge Sullivan granted the request to have interrogatories be submitted to Secretary Clinton.
And what are interrogatories?
And written questions under oath.
So she has to respond under oath.
Correct. It doesn't, with respect to, it's by comparison to a deposition, those are questions, verbal questions, and so you're able to ask follow-up questions. The interrogatories, the reason they're limited, they're written. You do them in advance. You provide the other side, they have 30 days or however much, if there's some other agreement, and then they respond in writing. And it's typically prepared by the attorney of the individual who's responding. So they're more limited.
And what did Hillary say in interrogatories? I'm trying to remember if she said anything interesting, other than I didn't do anything that I wasn't allowed to do.
I think that's pretty much what she has said all along. I mean,
so what's the legal issue behind what she did? What? So what? Right? That's kind of what her attitude has always been. So what?
Well,
what did I do wrong? Then
let's take that attitude with President Trump. So what?
I know, but right. but people forget, given what Trump's going through.
Right.
Exactly what Hillary did, which to me, I don't think Trump did literally anything wrong, but Hillary has no excuse for what she did based on my understanding of the law. Not only on Foya, but on kind of other issues related to handling classified information.
Well, one was the classified information, the communicating about classified information over unsecured email system.
So she was sending and receiving classified information.
Right, and we deposed, in this case,
off of
Jacob Sullivan,
who is now
National Security Advisor.
National Security Advisor for Obama. For Biden.
Well.
For all we know, he's acting president, given what's happening there in the White House.
But yes, so Jacob Sullivan, in his deposition, testified that he did communicate. Now, he said he didn't have knowledge at the time that he did not believe that the information he was communicating about was classified, but
everyone else knew
it was classified at the time.
Everyone else was nervous that it was a security issue around her, right?
Yes, yes, and there was, going back to the case before Judge Sullivan, I believe Ambassador Boswell was deposed, and he spoke with respect to the security. And the discussions they had with her staff, including Cheryl Mills and Huma Abedin, because with respect to the BlackBerry usage, and I believe Secretary Clinton also, I believe they also had iPads as well, which were not secure.
And then we subsequently learned that they were cycling phones and bleach pitting them and smashing with hammers and things like that. So all of this was being run out of the Clinton Foundation offices as a bathroom server or wherever you want to call it. This classified material was being transmitted. And so no one who was senior in the State Department who had access to her communicated with her through her official email account. They all used this Hillary.com account or Hillary Clinton. What was it, Clinton.com? It doesn't matter.
It does. I believe, ClintonEmail.com, I think. But
so they all knew. And what's interesting is after she left, they quickly understood, we can argue when they knew, and, I think they knew from the beginning based on the evidence. But after they left and they're giving us Foya documents, they hid kind of a smoking gun from us, didn't they?
Yeah.
And let's go to that. Let's go to that email, and you'll notice an email address there. It's from Jake Sullivan, dated September 29, 2012, a few weeks after the Benghazi attack, and it was to hdr22@clintonemail.com. And that was Hillary's private email address. And CC'd was Cheryl Mills, her top lawyer, who's responsible for FOIA requests as well. And we know specifically about these FOIA requests. They had that email and they didn't give it to us, even though it was responsive.
Right. And they didn't identify it as being responsive when they provided the records that they said that were back in November of 2014.
So they had this smoking gun email in 2014. So they in my view, they committed a crime in withholding information, committed a crime against the court too. I don't know, what's the new rule? Everyone can go to jail for obstructing official proceedings now? Is that what they were arguing before the Supreme Court?
Right.
Does a court proceeding count as an official proceeding? I would think so. So when there's a FOIA lawsuit and you're lying to the court about what documents you turn over, to me that requires a stronger response than, frankly, the courts gave. So this is a smoking gun, this email. We'll give you access to it below. We'll give you a direct link as well. So they knew in 2014 at least that they had documents responsive to our request that showed the Hillary email scandal.
And Tom, I would just say, look at the subject line, revise key points. These were Benghazi attack-related key points. So the idea that these records, anybody looking at this document, even skimming it, that it wouldn't catch your eye and being like, this should be responsive to a request about Benghazi talking points is not credible.
An email sent among the leadership of the Obama administration. This wasn't like sent to 70 people within the State Department. Here's what the media reports are this week about Benghazi. This is how we're going to respond as a United States government to the Benghazi scandal.
This was, I believe, in response to, because at that point, by end of September, there were calls with the Senate, and it was in response to a call with one of the senators about on the committee.
What had happened.
Right, what had happened. But specifically, the Benghazi talking points were a subject matter of that call. So
Susan Rice, who just recently left which Democrat administration are we in now? The Biden administration. She was a top official for Joe Biden for many years in the White House until recently. She was UN ambassador, our ambassador to the United Nations, and Hillary didn't want to go and defend Benghazi on Sunday morning talk shows, so they sent Susan, and she went and lied on each Sunday morning talk show about Benghazi being a video and not the result of a terrorist attack. Talk about election interference. Does that count as election interference too? I mean, the new rule is, and it kind of, the Clinton email scandal compared to the handling of the Trump document scandal is outrageous, right? But, as we've been talking about, we talked briefly before the show today, Donald Trump's on trial for messing supposedly with information about the 2016 election that could have impacted it one way or the other. How is this not the same?
I mean,
is Hillary going to get prosecuted now? I mean, I'm asking rhetorically.
Well, I know you're asking rhetorically because that's in the rear of your mirror. I mean, I think, Director Comey decided that, there wasn't enough probable cause.
So under FOIA, we're supposed to get records that are in the government, right? And when she left office, they weren't, quote, presidential records where she could have discretion in hiding and taking with her.
These records belong to the United States government. I mean, these were not her personal records.
What was the position of the Justice Department as to what Hillary did?
Well, to be honest, the position and the way, and again, it's about the process. What they did in this situation, she had 60,000, 30 she returned, and I'm approximating here,
Yeah.
right? 30 she said they're personal and then deleted them. I believe that's
Yeah.
the approximate number. But what the State Department permitted Secretary Clinton to do is for her and her attorneys to go through her emails and determine which ones they believe were state-related records and which ones were her personal records, rather than having somebody within the government to go. It's a system of records that she used. This is her way of communication at the time that she was Secretary of State. The appropriate method should have been to have somebody from within the government at the time, because Secretary Clinton was no longer, she was a private citizen, so was Cheryl Mills. Her former staff, they were no longer in the government. The State Department FOIA officials should have been the ones to go through those records and then be able to determine what was wrongfully taken from their system and brought back to the State Department so they can be archived.
And so her criminal lawyer or civil lawyer, depending on her current status, Hillary's status, was the one who went through this. And she was a State Department lawyer previously.
Yes, we're
So
talking about Heather
went through
Samuels.
and she deleted all the emails for Hillary. Not all of them literally, but those deleted emails, she's the one who
was
hit delete.
responsible going through and determining what was to be returned and what was not to be returned.
So, you know, on a lot of this is all coming out in 2016. We have the discovery of the Clinton email scandal. We have the Benghazi Select Committee appointed. We have also, as a result of this scandal being uncovered, that there was this new batch of emails. We've uncovered emails from Yuma Abedin and others showing that there was a pay-to-play operation going on in the State Department where Clinton donors were using the Clinton Foundation and access to Yuma Abedin and Hillary's emails to get special favors for donors, including foreign heads of state, you know, shady characters galore, and it was, you know, it showed that she was running a racket. And that had consequences for Hillary. And then, of course, the Anthony Weiner laptop showed up where a lot of Hillary's classified emails evidently were stored on. And Anthony Weiner, if I don't want to remind everyone what Anthony Weiner was about, you can go look it up because it's so disgusting to talk about. But, you know, a very unsecure computer by all accounts.
Right.
And that happened and popped up, and because it was exposed, because they were trying to cover it up. And before it was exposed indirectly, Comey admitted they had this stuff, and it was just a week or so or two before the election. And Hillary lost. And I think she lost as a consequence of this email scandal. We didn't do it, as we discussed. We were investigating Benghazi going back to 2012. We had no idea Hillary was running.
Right.
We just wanted the darn documents.
Right. And just to clarify on the previous point how this all started, the initial case, Tom, that we had with the Ben Rhodes emails, that's because we submitted that FOIA request to Susan Rice's office. And that's when we received the limited documents. And then we said, let's send a FOIA request to the Executive Secretary's office.
And arguably they
and
should
that's
have,
when.
Arguably they should have searched Hillary's emails then too.
Correct, but directly and for certain in this case.
Yeah, we wanted
because
to
the
be
request
sure.
was specific to her office.
So they basically obstructed us and played games beginning in 2012. We uncovered the emails, unfortunately for Hillary, in 2015. And the consequence was, and it wasn't the purposeful consequence, but the historic nature of it was that she lost the election. Now, the case didn't end when she lost, and unfortunately the Justice Department and the State Department under Trump didn't become any more helpful to us.
No.
So we did the discovery in the one case, the Judge Sullivan case, so that we had, again, two cases, one about Yuma Abedin, and one about Hillary. And Judge Lamberth came back around again after that discovery and said, well, you know, basically, what else do we need to do here? And what else did we need to do, did we tell Judge Sullivan?
Well, what the discovery was limited in the case before Judge Sullivan with respect to just Huma Abedin's emails, and that was the significant difference. Here we wanted to, and the request was specifically for Secretary Clinton's emails, and so we were limited in the questions that we were able to ask in the case before Judge Sullivan. So in this case, we were permitted to ask questions specific with respect to Secretary Clinton's emails, what the State Department officials knew, the IT officials, and the Foya officials. And by the way, one of the individuals we deposed in this case, if you recall, was John Hackett, who expressed enormous frustration with respect to
and he was a diplomatic security person, if I recall?
No, he was actually the head of the Foya.
Oh, he was head of Foya, that's right.
He was the head of Foya, yes.
That's right.
Yes.
And what did he tell us?
How even prior to this, there was, at one point there was a picture, if you remember, in the newspaper with Secretary Clinton sitting on a plane on a BlackBerry. And he saw that. And he said, what is this, what's the email that's being used? And this is his job, right? His responsibility is to respond to FOIA requests. So there, he assigned one of his officials, Ms. Tian, who we also deposed, to go and investigate.
And what were they
and
told?
She was, she expressed frustration from my recollection, and basically she was not provided the information that she was misled.
And I'm sure they'll pop up the picture as we're talking of Hillary's infamous.
You know which one I'm talking about.
Yes, with her sunglasses on.
Yes.
You know, and she pretended not to think that anything was important. You know, like wipe with a cloth and all of that. And that sort of arrogance, as I said, had political consequences.
Right.
So Judge Lamberth, you know, we still, in our view, didn't get access to everything we should have gotten as it related to Hillary's emails. And we got some discovery, and then we asked for the principal, the head of the agency, who also was the person responsible for hiding all these records, and we sought her deposition, and meaning we wanted you to be able, on behalf of Judicial Watch, to question Hillary Clinton in person.
Right.
And generally, what was that argument about? What was the argument we made, and what did Judge Lamberth rule?
Basically, she's the only one, because I believe, like you're saying, she's the one that made the decision ultimately to use it. And so the question had to be asked of her directly. Why did you use the system? And how did you think this was appropriate? And how did you think that your emails would be preserved, within the government systems, or, to respond to FOIA? And what was the second part of your question?
What did Lamberth say?
Judge Lamberth agreed with us, and we also requested the deposition of Cheryl Mills, who was her top aide, her senior aide. And Judge Lamberth agreed with us. Unfortunately, Secretary Clinton's attorney intervened, and then also Cheryl Mills' attorney, and appealed. And so Judge Lamberth's order was reversed on appeal.
So it's not unusual. We had, Judicial Watch had previously deposed senior officials, including former officials, like I think we were about to depose one Commerce Secretary, Ron Brown, before he died, a former Commerce Secretary, or two. So it wasn't unusual for cabinet officials to have to be deposed about government records issues. Right. I mean, in my view, the appeals court protected Hillary.
Yes.
I mean, they kind of upended FOIA law. They
went out of their way to protect Secretary Clinton.
Right, and compare and contrast what they did with Hillary to the craziness around Trump. Just compare and contrast. Hillary was too important as a former government official to even ask her about what she did with her records. Yet they raided Trump, a former president's home.
Yes.
Outrageous. And then we had another case where then once the leftists in the appellate court kind of ran away and protected Hillary. And by the way, we didn't get much help from the Justice Department under Trump.
No.
Not that Trump was running the Justice Department, but his
Right.
appointees, just refused to be helpful. They defended Hillary. To have the State Department and the Justice Department under Trump defending Hillary was infuriating. And I guarantee you Trump thought that was infuriating too, but that's another story. But we had another case for all of it. So then we filed a third lawsuit, as I recall. Remember this case, I think our colleague, friend too, Lauren, another senior attorney, had a Foya lawsuit. Well, now we know they're Hillary emails. Give us all the Hillary emails.
Right.
And the judge in that case said the State Department didn't have to search the agency for the records.
Right.
Because you just had to trust Hillary turned them over.
Right.
And why
that's
bother
the
having
problem.
anyone else? And so we saw the writing on the wall. So these cases were on a glide path to ending.
Yes.
As Hillary was getting protected. And that's where we are with the $97,000 settlement we just got a few weeks ago.
Right.
What do you think? Let me give you some kind of broad questions. What are the lessons that we've learned from this saga? I mean, I would just say, just to put like the historical context, our Benghazi investigation, which led to the discovery of the email scandal and these other issues we're talking about, was the most consequential non-governmental investigation in American history. It changed the course of history. Trump was president, I think, in large measure because of this investigation. And let's not forget we found some big things about Benghazi that are outrageous to this day, including documents that show that they had the military ready to go, and it was delayed by Hillary and others, and lives were lost as a result, likely. But what are the other lessons in terms of Foya, government accountability, corruption, judicial fear-based decision making, and everything else?
It just tells you just how important Foya is. And it's a tedious process, and it's a long process once you get into litigation and you're forced to file the lawsuit, because most of the time the agency never responds to the request. But you have to be patient, and you just have to keep plowing through and just wait. I mean, if something smells funny, it probably, there's something there.
So Judicial Watch is a nonprofit, right? And we do this for a living. This is our mission, to kind of uncover what the government's up to.
Right.
I mean, do you think a private firm or a media firm would have figured out how to do this? Would have figured this out the way we did?
I mean, it's there for anybody, whoever wants to do it.
The answer is no. No one would have. I mean, Congress, didn't Congress have the opportunity to figure this out? And they
You're talking about respect to...
Yeah, this Clinton email thing.
The Clinton.
I mean, you think about it. We had 1, 2, 3, 4 cases that kind of, in toto, kind of resulted in the consequences we talk about. But I can't imagine a private firm would have said, well, we're just... How much money are we going to spend on this? We don't have an interest here. Who has an interest in doing this other than Judicial Watch?
Because the public has an interest,
right,
in obtaining this information. So, I mean, and just going back, I mean, I think the reason the Benghazi Select Committee was formed, it was formed immediately after the Ben Rhodes email came out in our case.
It was in response to
It was in response to that.
Yeah.
So...
Congress followed our lead, and I remember as we were getting information out and talking about discovery, the FBI would leak that they were going to start questioning the people that we were talking about questioning personally.
Wow.
So even the FBI was trying to follow us, even however half-heartedly they were doing it. So Hillary's case ended with this massive settlement of $97,000. I think it's big because, we had one major settlement back in the day that took, years of litigation and discovery that was really had dozens of people being deposed, and that resulted in $900,000 given to Judicial Watch.
Right.
This case was much more limited, and some folks say, well, why didn't you get more money? And we can't ask for all the money in the world just because we, did an important lawsuit. There's limits under law as to what we ask for.
Right, right. And it has to be, I mean, like I said, there's certain limitations as to what you can request, but in general, right, the fees have to relate to the disclosure of records. So the work that you're requesting to be reimbursed for has to relate to disclosure of additional records. So, you know, we did all this work on the appellate side of the case, which was when Secretary Clinton's attorney and Cheryl Mills appealed Judge Lamberth's order, and we went all the way up to the Supreme Court requesting for writ of cert, and it was denied. But we couldn't. I don't think we would have been entitled to fees for that work in the case.
So we got what we asked for,
Yes.
and we asked for everything we could get under law.
Yes. Yeah.
So here we are. It's 2000. What year is it now? Not 2024.
24.
Trump is being threatened with jail. He's facing potential jail up in New York for writing in his financial ledgers, allegedly, I made a legal payment for something related to a legal dispute. And the Democrats in New York City are trying to put him in jail by calling that election interference. Do you think that's comparable to what Hillary did in 2016, A, and well, obviously spying on Trump and not reporting it correctly, as the FEC found, and then kind of messing with these emails to hide them from the American people? Does that, you know, I'm kind of asking you on the fly as a lawyer, but does that sound within the same crazy ballpark as to what they're doing to Trump?
I mean, no, I mean, to the lengths they went to protect Secretary Clinton, honestly, and since I've been doing FOIA work since being here for 11 years, I've never seen the government protect any government official to that length as they went and protected Secretary Clinton, and even just looking back in history.
Yeah, comparatively speaking, everyone else gets thrown under the bus in FOIA. If push comes to shove, they give up the documents, and usually that's the end of it. With Hillary, it was this crazy fighting that took place beyond.
And just remember, this is the records that her attorneys decided that they should reach her. So we'll never know, really, what records there were and what communications there were with respect to when she was the head of the agency.
You know, arguably there's a different generation of DOJ lawyers now, and so maybe things have calmed down a little bit. But from what I recall from the Hillary Clinton FOIA era, is that prior to that case coming, people will be surprised to learn that, Judicial Watch attorneys, we weren't always fighting to get these cases resolved. It was the Justice Department's negotiating and saying on behalf of the agency, what is it going to take for us to end this case? And you figure out what the documents are, and you just have what's called civil litigation. Quite literally, it's civil.
Right.
And then when Hillary happened, we had to, every sort of courtesy and consideration that we would get as a Judicial Watch, and you and your colleagues as attorneys, went out the window. And I would often joke, we had to go into court to get the time of day in the course of almost every piece of FOIA litigation for several years, because they were just so galvanized because of the Hillary cover-up. And it really it curtailed almost all FOIA litigation in terms of making it easier to resolve it.
Yeah, and my recollection is, really honestly, prior to this, the State Department, in responding to our FOIA requests, we usually never had a lot of issues because they pretty much complied. And
yeah. I mean, they were slow. They were slow, but they gave you good stuff. Yeah.
Right.
Not anymore.
But obviously, that changed, and we're finding now it's not just the State Department. It's the Department of Justice, with respect to requests we have there that relate to, for example, the raid on Donald Trump, President Trump's estate Mar-a-Lago.
Right.
And the pushback that we are getting in those cases as well. And one of the cases I have on that, the agency has said that all the records we've requested are part of the investigatory file. So we requested, okay, provide an explanation of where you looked, and because part of the communications.
If they're in the investigative file, they would be, quote, in the investigative file.
Well, part of the request that we asked are for communications, between the Secret Service and also the White House. And so the question is, what is part of the investigative file that are related to communications with the White House? And notably, what we'd want to know are those communications before or post the raid.
And what has there been responses on that? What's the detail on that?
They've refusing to provide, so we're going to go and they're going to brief it. They're going to file a summary judgment motion in court, and so we'll have to argue on the briefing.
So they're essentially saying it's a state secret as to whether we communicated, if at all, with the White House about our efforts to jail Trump.
Well, they're admitting that there are responsive records, and that's it.
So
they stop there.
So they confirm they talked to the White House about the raid on Mar-a-Lago.
They confirm there are responsive records.
Okay, so
Right.
Are we saying the same thing?
We are saying the same thing, yes. I'm being a lawyer.
This is what my days are like at Judicial Watch. I'm speaking English. But as you can all see, we've got a great resource with Ramona here at Judicial Watch. And
thank you.
that was quite the case. I mean, we were laughing before the show because we don't remember everything you would think we would remember.
A lot of it is coming back, but it's 10 years of litigation.
Yeah,
That's a long time.
Yeah. And I think it's in our last book, Republic Under Assault. We covered the Clinton email scandal pretty closely there.
Yeah.
So I encourage you to get the most recent Judicial Watch book, A Republic Under Assault. We have a new one coming in the fall, so pick that one up. Ramona, thank you very much. I think we covered all the bases here. Thank you, everyone, and I'll see you here next time for Judicial Watch.